Dean, are you ready?
Yes, I am.
We're ready.
Okay, doke. I'll go after 3. 1, 2, 3. Good afternoon, ladies and gentlemen. I should say good afternoon. Some it's night.
Good afternoon.
Good evening to others. The conveners and planning committee of the Coffee Time are pleased to welcome you, both those in Jamaica and those overseas, to our annual Maurice Stoppy Lecture Series. We're pleased that you have chosen to be participants in this forum, and we are sure you'll benefit immensely. Coffee Time is an online space that has been established by the Jamaica International Arbitration Center, and it supports scheduled and from time to time ad hoc discussion, lectures, and in capacity building and other initiatives in the field of dispute management. Today's webinar is entitled Value Chain Economics in the Construction Industry, Targeted Deliverables, Project Management, Dispute Resolution, and it's brought to you with the support of several sponsors whom you'll be hearing from in a very short while. I'm Dean Burrows, Chartered Quantity Surveyor and Arbitrator, and partner at the firm Burrows & Wallace, Chartered Quantity Surveyors, and I'll be your chairman taking you through the activities of this afternoon, the highlight of which will be the Maurice Stoppy Lecture, which will be delivered by Professor Dr. Mohammed Abdel Wahab of Cairo University and head of Zufcar and Partners Law Offices in Egypt. Once again, because of the COVID pandemic, activities are condensed and the lecture will be delivered online. The COVID pandemic that was considered to be a setback has enabled us, by using technology, that's through Zoom, to be able to teach from far afield to our shores and to provide you with a breadth of exposure to alternate opinions that would not otherwise be possible. The other scheduled event which will follow the lecture will be the panel discussion to be moderated by Karen Goff, a barrister in practice at 39 Essex Chambers in London, and she's an attorney at law and past president of the Chartered Institute of Arbitrators. Karen has an audience in both Jamaica and Trinidad and Tobago, and she possesses a wealth of knowledge on the matters of dispute management. The panelists for that discussion will be Dr. Amar Abbas of Egypt, Mrs. Suzanne Lyon Jacobs of New York, Mr. Hannah Judo of Mauritius, Mr. Robert Gerard of Singapore, all eminent professionals in their fields and which should give an international perspective to the discussion. The focus on construction industry is not misdirected because while not always evident, buildings and infrastructure represent the greatest proportion of the assets and investment within a country and comprise possibly the largest repository of wealth in the country. It is undeniable that this wealth is aggregated with ownership distributed widely across the economy and includes assets both owned by private individuals and the government. It's this wealth with which we are concerned and its management and maintenance and its growth. Now, despite the COVID pandemic, we have seen some consistency in Jamaica, even an uptick in investment in construction and real estate all around us, both in urban and rural areas. And this indicates that individuals are interested and are pursuing, maintaining, and increasing their wealth. The wealth generated in this industry emerges out of the employment of adversarial agreements as employers aspire to achieve maximum returns from their investment and contractors endeavor to maximize profits from the building activities that they do. No wonder that disputes arise. And it is in this environment that I've just described that a visionary like quantity surveyor and arbitrator Maurice Stoppy emerges and introduces some 40 years ago a course by which individuals, whether employer or contractor, could have their dispute resolved without resorting to the courts. Now, even at that time, the courts had become bogged down with a backlog of litigation, averaging over 6 years to resolve a simple construction matter. From his engagement as quantity surveyor, as the manager of the financial portfolio construction projects, Maurice stood as a neutral, most times having to exercise equity between the employer and the contractor or their agents on construction contracts. And it's from this vantage that he encouraged arbitration as a private and more efficient and expeditious process as an alternative to the courts to resolve disputes that arose. Arbitration is seen as a more expedient process, taking on average less than 1 year to resolve a typical construction dispute. The practitioners of dispute resolution are aware that any dispute, two rationality must be contended with. One, the individual rationality, which requires impartial examination, reviewing and judging of contested facts and contrary arguments, and the social rationality, which requires equitable procedures and rules for the peaceful settlement of disputes in a manner respecting the basic rights of the parties in the dispute. And in Latin, one would say, audi alteram partem. It's on this foundation that the application of alternate dispute resolution methods have become widely acceptable and accepted in resolving commercial disputes, both locally and international. The Jamaica Arbitration Act, enacted in 2017, which replaced the moribund 1900 Act, facilitated the reemergence of the option of arbitration as a suitable course of alternate dispute resolution. And in enacting the Act in 2017, the Jamaican Parliament agreed that the prevention and resolution of conflicts on the basis of agreed rules and just procedures should be the common objective for engagement of national and international disputes. The Jamaican Act adopted the United Nations Commission on International Trade Law, that's UNCITRAL model law, and the procedural rules attached, and this provides a uniform structure and framework for conducting arbitrations. Today, as we look back and we see the various configurations in which alternate dispute resolution have morphed, we honor Maurice Stoppy for being among those taking the first steps in this direction and providing outstanding service to the construction and real estate community in Jamaica. Now, several quantitative surveyors have followed Maurice Stoppy's example in becoming arbitrators, specializing in construction disputes. However, the application of alternate dispute resolution procedures and techniques into other areas of the economy have seen these methods becoming acceptable by the general public in resolving a wide range of disputes. Alternate dispute resolution have gained substantial traction and now plays a pivotal role in our courts. Judges now require that some disputes should be first referred to alternate dispute resolution through mediation prior to a case proceeding to trial. The development of infrastructure across the island has brought to the fore the need for expertise in the area of adjudication to settle matters of land values where compulsory purchase are becoming necessary. Now, without a doubt, the construction industry has been a perfect example of how effective these types of dispute resolution methods can be employed in managing and maintaining wealth. The Jamaica International Arbitration Center provides this forum that will ensure that best practice principles are employed in all cases where disputes arise. And I would encourage all practitioners to get in touch with this center to see the offerings that they have there. We have come quite a long way, and we salute Maurice Stoppy in being a pioneer in this field. At this time, I would like to invite Mr. Stoppy to share a few words with us. Maurice.
Thank you very much, Chairman, fellow quantity surveyor, fellow arbitrator, Mr. D. Burrows. Many thanks for your kind introduction. I'm not sure, and I'm not certain at all, that I'll be able to live up to the accolades expressed by you. I'll simply try to do my best. But it gives me a great deal of pleasure, personal pleasure at this time, as a long-standing member of the Jamaican International Arbitration Center, and on behalf of Dr. Christopher Malcolm and board members, to extend to all the contributors and attendees to this, the sixth in the present series of annual meetings. We are indeed grateful that all present could find it possible in these troubled pandemical times to join us in what promises to be a highly rewarding afternoon. I pause briefly, my friends, to comment on the universal complaint we often verbalize of regarding the uncomfortable restrictions imposed on us by the COVID-19 pandemic, and in pausing, also to praise and to be thankful for some innovations that society has produced to alleviate some of those restrictions, particularly those of quarantine. One such benefit in which we are all participating here today is the virtual Zoom system enabling us to effortlessly attend such a conference with participants spread from as far afield as the UK, US, Hong Kong, Jamaica, Egypt, Mauritius, and so on, without the previously uncomfortable and usually most expensive methods of overseas travel and accommodation, etc. It is my hope that this relatively new technology will expand in the near future to bring us at disparate geographical locations and of similar interests and pursuits closer, to enable the free exchange of progressive ideas and technologies. It is with all of this in mind, my friends, that I'm exceedingly happy, indeed honored, on behalf of all of us here, to extend a hearty Jamaican welcome to our colleague and friend from the Arab Republic of Egypt, Professor Dr. Mohammed Abdel Wahad. And I think that deserves a slight round of applause. A welcome which will later be and more appropriately expanded upon when more properly introduced by Dr. Malcolm, who will no doubt expand on the moot of this meeting, value chain economics in the construction industry, project management, and dispute resolution. And I'm sure that you will agree with me, this represents a wide range of highly important current topics, and from which I'm sure we will all tremendously benefit. Once again, my friends, a very hearty welcome to this seminar, and we hope you will gain and enjoy the product of the deliberations we are about to receive. Thank you.
Thank you very much, Maurice. We'll be hearing from some of our sponsors at this time, and I'll invite Mrs. Judith Larman Henry, General Counsel and Company Secretary of the National Housing Trust, Mr. Martel Lee of ADB Consultants Limited, and Mr. Lee will follow her, and Mr. Lee will be followed by Dr. Christopher Malcolm, and Dr. Malcolm is the Secretary General of JAIAC, that's Jamaican International Arbitration Center, and Senior Lecturer, the Faculty of Law at the UWI Mona campus, and Dr. Malcolm will introduce our guest speaker for the afternoon. So they'll follow immediately like that. So I'll be handing over to Mrs. Larman at this time. Thank you. Larman is there. Can we move on to Mr. Lee from ADB Consultants?
Good afternoon, Chair. Good afternoon, all participants. Martel Lee, ADB Consultants. Let me express my thanks and gratitude for participating in this forum. I think it's a worthy approach to some of the situations that encompasses the construction engineering industry. It's a simple, straightforward process, if done correctly, that we can use as a tool to resolve some of the simple and even more complex disputes that we come across. ADB, I must briefly say, has been around since 1964. So we have been around a long time, and we have seen just about all types of disputes and litigation process, which to engineers and builders, contractors, it's really just a setback in the process of achieving our objectives. We strongly want to recommend this to our clients, and we have been using a form of contract, which is FIDIC, and in the section of FIDIC, section 20 onwards, actually looked at the method of claims and resolving disputes, which goes up to the process of arbitration and sometimes beyond. For us, it's an instrument that we find very productive, easy to resolve problems at times, and reduce some of the difficulties with the construction industry. And we want to get on with the business of design and development, not litigations, etc. On this basis, I would like to thank the arbitration panel in advance of what is being presented here, and simply to say that ADB Consultants is one of the oldest engineering institution in Jamaica, endorses this process and will continue to do so because it adds value, it is efficient, and it allows us to resolve issues stage by stage if done properly. And we will encourage all developers and institutions around this industry to look at how the arbitration process works and how it can be implemented and perfected if possible to aid the process of development, especially in a country like ours, where the litigation process is already tied up with major activities which are outside of the construction industry and more complex in the way they are being resolved. So, Mr. Chair and others, let me wish the panel and others all the best. And I'm looking forward to what is being contributed here and now. Thank you very much.
Mr. Bars, you're on mute.
One of the things that we have had to exercise is flexibility. And we have had to exercise this flexibility this afternoon. We would have loved to have heard from the National Housing Trust because they are one of our largest sponsors, and they are responsible for quite a bit of construction and real estate activity in Jamaica. But this evening we are unable to do so. I'm sure they'd apologize for not being able to make it. So at this time, I'm going to be going straight over to Dr. Malcolm. Yes, Dr. Malcolm.
Yes. Good afternoon, evening, morning, night, wherever the persons may be. Thank you, Chair, for having had the proceedings commenced. And certainly, I must at this time say special thanks to Maurice for having made himself available to be here with us and for having given us the opportunity of having this lecture series commenced in his honor. Of course, we thank all the panelists, in particular our guest lecturer, Mohammed Wahab from Egypt, and also my good friend Amma from Egypt as well, both of whom are linked to Cairo University, and Amma and I, in fact, go way back to Queen Mary University, London. So we do know each other for quite a while. And of course, I expect that we'll have a wonderful program. But getting back to the present and what I'm here to do today, I, of course, bring you greetings on behalf of the Jamaica International Arbitration Center and the broader community across the Caribbean region and beyond, persons who are interested and involved in the field of ADR. We have been working very hard, I think, as a region to build out great appreciation for ADR and what its value and utility is. And we have, in the context of the JAIAC in particular, developed this webinar series that we have been on called Coffee Time at JAIAC, where the ultimate objective is to bring us closer together, to share experiences, and to try to, as much as possible, ventilate issues which can help us to a better understanding of how we may be able to assist our clients and assist the economic growth and development of the societies in which we live. This afternoon is no different. This lecture that we're going to be hearing, which is focusing on value chain economics in the construction sector, and the panel to follow, will be looking at some critical issues of how it is that projects can be better managed, how it is that they can be managed much more profitably, and how it is as well that you can ensure that disputes which really affect every arrangement, whether they're personal, professional, whether they're of a commercial nature or otherwise, they affect them all. And the question is, how do you ensure that you have better systems in place to manage them with something that we as commercial persons have in mind, with profit in mind and with sustainability in mind? Those are some of the questions I am certainly, as an attendee, anxious and keen to hear about. But to the present as well, I have the grand privilege of also in this very short way introducing our guest lecturer, Professor Dr. Mohammed Wahab. Now he goes without, I mean, I could go on and on speaking about this Professor Wahab, but I'll simply say, go to the website, coffeetime@jaiac.com, coffeetimejaiac.com, and you will see his profile and that of all the other persons who are involved as panelists here. But it would be remiss of me not to say a little bit though. He is, without doubt, a leading global figure in the field of ADR and arbitration, not just as a practitioner, but as an academic and as what we would consider a significant thought leader in the field. He's from Egypt, but he really is a product of Egypt being made available to the world. He really is a world citizen, and his antecedents show that without any hesitation. He's a member of multiple panels across the globe, and he is called upon on multiple occasions to speak in a way that he only knows too well, to engage with persons and to share of his own knowledge. In fact, only today, I know without even thinking that he has already delivered another lecture in another context. So for him to be up at midnight or thereabouts close to in Egypt to share with us is in fact a grand thing, and we are very happy to know that he was prepared to make himself available to us in these circumstances. We thank him and we thank all the others who have been kind enough to share of their time. And I know that we will all learn a lot from this process, and I am expecting to certainly sit back, relax after having said my 2 words, and simply enjoy the proceedings hereafter. Thank you, Chair, for this time, and I turn back over to you. Chair, you're on mute.
Thank you very much, Dr. Malcolm. Before our guest speaker comes, we have a message from our sponsors.
I save because one day my little business is going to be a big deal.
Yeah, and I make sure to put away a little something for him.
And thanks to JDIC, deposit insurance protection on my savings gone up.
You've been upgraded. Deposits held in commercial banks, building societies, and merchant banks are covered under the JDIC deposit insurance scheme up to $1.2 million per depositor per institution. JDIC.
Protecting deposits for you and me.
Now we'll have our guest speaker, Dr. Mohammed Abbas.
Thank you very much, Mr. Barrows. Let me start by saying it's an utmost pleasure to be amongst you today and to deliver this lecture in the very presence of the pioneering figure, Mr. Stoppy himself. So it's an honor and a privilege being invited by Jamaica International Arbitration Center. And I'm very grateful for the very kind words delivered by all colleagues, including Dr. Malcolm, who actually gave me more than I deserve. Let me start without further ado by saying that I'm going to use the words of the chair of the Board of Trustees of the Chartered Institute of Arbitrators in a meeting that just took place yesterday, when he said, if there is one thing that we will miss when this pandemic is over, it will be the statement, "You are on mute," because that is very frequent in international events, conferences, and webinars. It is very rare that we come across a situation where any one of us would not be muted one way or the other. Now, without further ado, I think, given the time I have, I will start with my presentation, and I hope you all see it. It's about deconstructing the construction landscape in a changing world, managing expectations, projects, and disputes. And I had a lot of thought about what could be said in 30, 40 minutes or so that could be of interest to the great audience we have from across the globe. And what I want to go through with you, basically, let me start with that, yeah. 5 specific topics. I will start with a brief overview of the sector that is very close to our heart, construction sector, addressing a bit of its specificities and developments. I will move on to address value chain aspects, project management in the construction sector, which is becoming all the more very relevant and important. Causes of construction disputes, which I know is not alien to most, if not all of you, but putting them together in one place and reminding ourselves of this is important as we charter our way into the crisis mode, how we deal with those in terms of dispute avoidance mode, dispute management and resolution, before I make some concluding remarks about handling and managing expectations, and ending with about 7 comments about the future of the industry and 4 comments on the disputes relating to the future of that industry. Let me start by saying to us, and to me specifically, which is again a field that forms part of my daily work, it is a colossal sector by all means. And having used the word colossal, I thought of no better way to present this to you other than to bring to you one of the 7 ancient wonders of the world, the Colossus, from which that word originated. And quite the irony, the Colossus which did not survive until that day is one of the great wonders and is actually a creation, a construction, a construct, even many, many, many years ago. And indeed, construction is a colossal sector. To give you an idea, of course, construction projects are inherently dispute-oriented. In mega projects, in small projects, in medium projects, it is unlikely that we come across a situation where we encounter a project that did not spawn a dispute. It may be the situation, the dispute has been settled amicably early on, but it does involve its fair share of disputes. Why? Because these projects are normally complex and to some extent and possibly complicated in a way given the relationships. They are fact intensive and involving numerous disputes given the number of stakeholders at play and the multi-contracts aspects. Name it, we've got main contracts, subcontracts, financing, supply, insurance, operation and maintenance, and a lot more. They normally also have high value and high volume type of claims in mega projects. And we have a number of standard terms and conditions model contracts, FEDIC, the NAC, the JCT, and many others. And also we have the bespoke arrangements in the particular conditions. And disputes also arise because of the sort of changes made in these particular conditions that may or may not address or disrupt the risk element in the standard agreements. And also experts are at the heart of these disputes. It is, again, a very important aspect of disputes and projects that we have experts, both technical, quantum, programming, delay, again, a lot on board. And they are extremely voluminous in the documentary record. I recall in one construction arbitration I was chairing, we had one exhibit that was in itself 11,972 pages, and that's one exhibit out of thousands. And I recall as part of this, perhaps in the interest of discussion, and I think that is a duty for the tribunals when they read through and address this is to be transparent about the parties and in terms of managing the expectations. And I discussed with my co-arbitrators how are we going to go about with this voluminous record, including that specific exhibit, which was cited once by the parties in all their submissions. Are anyone going to be looking, or is anyone going to be looking into 11,972 pages? And my colleague said, absolutely not. And I told them, if that is the case, then we should bring this to the attention of the parties to be guided by them. They said, but if we do so, we risk coming across as not reading the case file. I told them, to the contrary, by doing so, we're going to ask counsel to guide us as to whether they expect us to read that 11,972 pages or not. And I put this question to the parties in the hearing, and they said, we as parties did not go through all that. So I told them, if you want the tribunal to do so, you should guide us about the important aspects of that specific exhibit, because the tribunal is going to go through all the exhibits anyway. And I think that is part of the process and discussion that arbitrators should have openly with the parties to ensure that expectations are managed efficiently and properly. A little bit about the statistics that I think are important to put things in context. And I looked at the past 10 years, and a lot can be said. Well, the global construction sector, even in 2011, accounted for no less than 11% of the global GDP. And it was projected at the time to account for 13.2% in 2020. We have now the global construction industry in 2018 representing 13% of the global GDP and projected to account for almost $14 trillion by 2025. Now, of course, given the COVID pandemic and crisis, as I would like to call it, there has been a slowdown. Indeed, the construction industry was not immune, but it has not stopped. It has continued throughout, despite the challenges of COVID, and is growing at an accelerated pace. Indeed, people think that it's going to be at almost 5.2% more than what we've encountered in the past couple of years. Looking at 2019, at the sort of statistics that are at least available, the building and construction and operations accounted for the largest share of the global total final energy consumption, 35%, the construction and building sector on its own out of the energy consumption. And the global total energy related to CO2 emissions, 38%, again, very high when we look at the importance of taking care of our environment and the rising voices relating to climate change. And then the construction industry, again, took in itself 55% of the global electricity consumption worldwide. So indeed, a very colossal sector and a very crucial sector for the global economy and for jurisdictions across the globe. That said, looking at the top 12 construction markets worldwide in 2020, we see that China is at the forefront, 32%, and this comes at no surprise. And we will even see shortly that 41% of the leading construction companies are geographically concentrated in China. The US follows with 12.3%, and the list goes on up until the UK. So the top 12 spots are basically in Asia, Europe, and Australia, but it's still very important for the rest of the world. As I mentioned, the largest construction companies based on geographical presence, China leads with 41%, and it's got the top 5 leading construction contractors worldwide, which are undertaking projects across the globe. Europe collectively follows with 26%, Japan follows with 13%, the US 9%, South Korea with 7%. Now, looking at the specificities in certain regions, one thing that came across, and I thought it's important fact to share, the residential segment is indeed the largest segment within the construction industry itself. So investments and work undertaken in the residential segment is by far the largest within the largest sector of the global economy. In Africa, the construction market, and everyone knows that Africa has opened its doors for investments and is a greenfield in many respects, including infrastructure projects and construction, is a big boom now on our continent. The construction market accounted for almost $5.4 billion in 2020, with even a compounded annual growth rate of 7.4% over the next 5 years. The African construction industry, again, being a destination for most large economies, we see that China, Japan, Korea, the US, and many European countries are investing heavily on the continent. The transport sector is at the top of the construction projects in Africa. We know that Africa has a lot to do in terms of building roads and infrastructure, and transport is important, followed by power, energy, and real estate segments within the construction sector. In Latin America and the Caribbean, the construction sector represented 6.1% of the GDP in 2019. And in China, 7.2%, and that decrease understandably decreased to 6.8% because of COVID situation, but expected to pick up over the next 5 years. In Australia, the construction sector accounted for 8% of the GDP in 2018, and that increased to 9%, and it's the compounded annual growth rate is expected to be in the range of 8% over the next 5 years. Now, moving to the second part of my presentation, relating to value chain and efficient project management. Value chain, as many of you would know, was a concept coined and introduced by Michael Porter of Harvard Business School in his seminal work, Competitive Advantage, Creating and Sustaining Superior Performance. Now, Michael, in his book, coined the term value chain as a business model describing a full range of primary and secondary activities. And when you look at the figure on the right-hand side there, you would see that amongst the primary activities, inbound logistics, operation, outbound logistics, marketing, and sales and services. And this indeed applies to construction across the board. And the support activities there in relation to the infrastructure, human resources management, technology, and procurement. And I would dare add, dispute resolution is indeed one of the support activities for the industry, be it in the form of dispute adjudication and avoidance boards, or arbitration or mediation. It is indeed a support activity that caters for the functioning and operability of the construction sector at large. With that in mind, and given that value chain as a business model describing the primary and secondary activities from, let's say, inception to conclusion, I now move to the application of this into the construction world. And if we apply the value chain sort of model in economics, we find that in the construction, it raises a lot of issues because it comprises actors and activities, financiers, developers, regulators, engineers, contractors, suppliers, owners, and ultimate users of the constructed or elected type of buildings. And the activities are, again, myriad. We've got feasibility studies, planning, engineering, design, procurement and tendering, marketing, manufacturing, supply of materials, building, testing, commissioning, and operation. And that's why we think of the field as a fragmented one, because of the convoluted and interconnected relations within the field in a way. And that brings about the importance of efficient project management and value chain economics to the mix. And that's why I thought of putting together to you the elements that I, wish to bring to your attention in relation to project management, feasibility, procurement, operation, and maintenance. And when you look at each and every aspect of those, I tried to gather all of them in one place. You will find that there is a lot of complex relationships there, starting from the tendering and procurement up until the actual completion of construction, with subcontracting, supply, commissioning, design, cutting across, and supply of all materials. And we've seen how the COVID crisis has affected each and every aspect of this value chain and of this project management loop. Now, because we're considering this, it would not suffice just to shed light on these activities and mention them in a way. We need to put to test this in terms of how and what we've seen in terms of construction disputes. Now, I group them in terms of owner-related disputes, and these, of course, procurement and tendering, change of scope and variation, as many of you would know, delay in giving site possession, acceleration, unrealistic expectations, which actually plagues the industry, if I can use that term. People start with a project thinking that it could be finished in the glimpse of an eye, and then along the way we find changes, variations, and delay is at the heart of the disputes. Delay in payments. We know that this field, which is a powerhouse, is actually powered by cash, and so cash flow is important. And delay in payment and certification of payment and claims is indeed an owner-related type of dispute. And then we come to the contractor types of disputes, where we find delays in work progress, financial failure on the contractor side, technical inadequacy, problems with the quality of the works, incomplete, unwarranted, or unparticularized claims in a way, to the extent that one encounters sometimes a situation where instead of the parties engaging in the business of building something, they went into the business of prosecuting claims. From day one, claims are put forward, and that creates a lot of problems. It actually disrupts the workflow, it causes a lot of problems, and may indeed impact the project at large. So again, we need to define what we want from the project itself. Is it about the claims or about concluding and completing the works in the best possible way? Now, that is said without prejudice, of course, to the fact that claims are indeed, in many instances, warranted and deserve to be addressed. But the question is, do they deserve to go all the way to arbitration, or can they be settled early on? And that, I think, is the value of value chain and project management in a sense. To the extent we're able to avoid this, and I will address that in the later part of my lecture, because that is, I think, one of the main problems we encounter in the field. And then, of course, design-related, design errors, incomplete, inconsistent specs, problems with availability of information, inconsistencies between the drawings, the shop drawings, and the initial specs and designs. All these are problems that we encounter in practice. And contract-related. One of the most important causes of construction disputes is basically that the contract signed by the parties is not the best fit for the project itself. So the parties fail to choose the right type of contract for their project. Think of it as a person or a man wearing a suit that is not his size, or a lady wearing a dress that is not her size. You need to find the best fit and the most appropriate terms of the contract. And if we cross that hurdle, we find another one, ambiguities in contract documentation. Construction contracts are known to be going into hundreds and sometimes thousands of pages. And with these, and knowing that in any event, there will be ambiguities, inconsistencies here and there, it is not uncommon that disputes arise in this respect. And then maladministration of contracts, when the engineer or the project manager or whoever in charge with the decision making is held back or is unable to administer the contract efficiently. And then the disputes accumulate and we have a backlog of disputes. Risk allocation. And that's one of the things I always tell clients when we advise them. If you take a contract or a template that has worked well, be careful with your particular conditions, not to disrupt or create a disequilibrium into the risks in this contract. Because if you do so, that is a recipe for dispute, and undoubtedly, you will have your day in court or in arbitration. Non-implementation of contract terms by the parties in practice. I've encountered cases where the parties have signed a contract, pretty good one, but both of them, or even more if it's multi-party, have put the contract on the shelf and started prosecuting or dealing with the relationship in a manner completely inconsistent with the contract that they have signed. And here we have the inherent tension sometimes between common and civil law jurisdictions, where would you look at the parties' conduct, pre or post-contractual conduct, or would you take the black letter agreement in application? Again, a further reflection on aspects of disputes. And then I think one of the most important aspects that I see overlooked and cuts across all those, the human behavior element. Absence of cooperation. Construction contracts are supposed to be built on cooperation and collaboration. It is an implied term possibly in many construction contracts across the globe. Cultural considerations. You may find the contractor constructing a project in a jurisdiction that is unknown to them. They bring their workforce. And here I think cultural considerations are at play. And we need to be sensitive to these elements and have a dialogue regarding these considerations. Lack of communication is at the heart of the problems across all these aspects. If people engage in meaningful, good faith cooperation, bona fide cooperation, in a type of team spirit thing, I think many of the disputes could be resolved. The question and the problem is many take polarized views, and then it falls on the shoulders of the arbitrators and courts to decide the disputes accordingly. And then we have project-related aspects, site conditions, unforeseen changes in the soil or the project itself. And then finally, what I call the other factors, weather conditions. And here it's a very interesting thing. When the parties contemplate the project being built over a certain period of time and have carefully chosen a window of time where weather works well with them, then because of disputes that have arisen, they find themselves having entered into a window where the weather conditions militate against the continuation of the project works in a proper way. And we have then a legal dispute about whose fault is it that we have now entered into the window that we have tried to avoid at inception of the project. Then comes the political, legal, and economic aspects and conditions unaccounted for. Change in law, regulations, market conditions, or sometimes appetite for the project, which has taken a long period. And we've seen that with the COVID-19, the change in priorities, change in appetite to certain projects that has spawned its own disputes. And then third-party works and obstacles. The interface between contractors in a huge project, when we have milestones and subcontracting, or even contracts allocated or given to different contractors. The coordination of the works of these contractors begs the question of whose responsibility is it the delay? And I think that is indeed important as one aspect and one factor that's sometimes overlooked. And then the sector fragmentation that I referred to earlier, because of the multiple actors and the multiple relationships that exist. And again, capitalizing on the value chain aspect and proper and efficient dispute management. Now, this brings me to the aspect of dispute avoidance, management, and resolution in a crisis mode. We've all encountered COVID-19, and we've experienced and witnessed the calamities, the problems, even if felt differently across aspects and across different jurisdictions in the globe. But still, the situation remains that it is a crisis. It is something out of the normative order of things that has destabilized and indeed imperiled the social, cultural, and economic environments for construction projects. It has been an unforeseen crisis, but construction as a field did not stop. It adapted, it continued, and despite not being immune, as I say, it did not come to a standstill situation. It continued because indeed it is entangled within the human behavior and for societies at large. And with crisis, I think the key word is crisis management. And many companies have not had the benefit of receiving guidance or putting in place crisis management plans, or what we call CMPs, before COVID hit. But once it hit, many companies now are putting in place CMPs because they have seen the damage that has been caused. And again, for the construction sector, this is extremely important because the absence of a crisis management plan can lead to financial difficulties and sometimes even companies went bankrupt. We need to have specific goals, risks assessed in a way. When we look at CMPs broadly, we find that they are divided into three phases: pre-crisis, during the crisis, or we say crisis response, and post-crisis. I'm not going to spend much there, but I can, of course, share this with whoever is interested. But basically, in a pre-crisis mode, a CMP would require identifying the risks, developing risk mitigation policies, building and training crisis management and crisis response teams, establishing policies and pre-planned responses to crisis when these crises hit. And companies and institutions that have had CMPs in place have managed better their way and navigated their way through COVID compared to others. But if we are in a crisis mode and we have a crisis response, you need to have an immediate action plan within the business model, efficient and accurate handling of communications externally and internally, actions being taken in accordance with tailored specific crises and CMPs in place, engaging cost-effective and cost-efficient use of resources, and applying crisis response measures. Now, if we do not cross both hurdles in avoiding the crisis or dealing with it efficiently, we are then in a post-crisis situation where we have to put in place an expedited plan to normalcy, undertaking an assessment to reflect on the past, look into the present, and provide a trajectory for the future. Looking at how the institution or the company performed during the crisis and revisiting the KPIs, the key performance indicators for future services and operations. And this is indeed essential for construction companies. And we've seen advisors advising construction companies on these CMPs and post-crisis mode action plans. Now, moving from the business aspect to the dispute side, we have dispute avoidance, dispute management, and resolution. To me, I always think of arbitration as a surgery. And you go to a surgeon when all other efforts have failed. You try your way with avoiding medication, avoiding the illness, but if the illness hits, then you have to deal with it by medication. If it fails, you go to surgery. So if we take dispute avoidance, which I think is indeed very essential for the construction sector and often underestimated the power of it, negotiating balanced and clear contracts, which I call the pacta equilibrium. If you have a proper equilibrium based on realistic expectations, a balanced contract that the parties follow, that in and of itself is a good recipe for dispute avoidance. Now, that's easier said than done. I realize that. And there comes the bona fide communications amongst the players to resolve issues before they escalate to dispute, hence dispute avoidance. The issue is we want to address the matter as it arises before it transpires or changes or actually morphs into a dispute. Proper administration of the contracts is key, early evaluation of risks, and avoiding taking polarized positions in contract claims is essential. Now, if dispute avoidance fails, and along this line, dispute avoidance and adjudication boards can be of great help to resolve issues as they arise, then we enter into the dispute management mode, and that is key towards a proper resolution of the dispute. So now you enter into the situation or the realm of fact-finding and early expert engagement. That is key. Preservation of evidence, because you will need it. And I think objective legal assessment. And I say that because in some jurisdictions, not of all, legal assessments sometimes are made from a subjective stance. You need to address that objectively to realize where you stand on certain claims. Then engage in efficient communication protocols with the parties that are at play in your project and explore amicable settlement options and make best use of the multi-tiered dispute resolution clauses. Instead of having a battle about whether you can avoid applying a tier or not, why not make the best use of negotiations, and if that fail, perhaps conciliation or mediation or even expert determination in certain situations before proceeding with a fully fledged dispute in arbitration. Now, when it comes to dispute resolution, the key recipe that I will present to you, you need to have a dedicated team of internal and external professionals, not just lawyers, professionals, quantity surveyors, you have advisors, you have experts, you have witnesses. You need to have this harmonious team that is working on the case. And then careful selection of neutrals or arbitrators is key. As often said, no amount of good lawyering can rectify the wrong decision of choosing the wrong neutral or arbitrator for the case. Preparing realistic budgets, arbitration is expensive, and going to arbitration is indeed costly. So preparing realistic budgets is key, and engaging in cost-effective and time-efficient bespoke dispute resolution processes. In a very recent case, construction case that I'm presiding, the parties have replaced the traditional dispute resolution process of engaging in several rounds of submissions and expert reports, joint expert reports, hot tubbing, and a lot more like that. They replaced this with a very bespoke process, which is engaging the parties' experts from the very beginning to try and reach consensus and reduce the areas of dispute. And then once this is done, the findings of the experts will be binding on the tribunal to the extent that they are in agreement. And if they are in disagreement, the tribunal will look into the matter and decide the case. That may not always be ideal because the tribunal will have to grapple with situations where they don't have traditional expert reports or findings, but it does reduce the time and cost of the proceedings, at least significantly. I've also encountered in another case a very interesting application or development where the party appointed experts, following the hearing on the merits and following their work with the parties, the tribunal, in collaboration and in agreement with the parties, decided to use those experts in confidence with the tribunal up until the award is rendered. So the parties would only pay the experts their fees, but will not have insight as to what the experts are doing with the tribunal to assist with their work. Construction is a field that is open to innovation and a lot of bespoke practices. There is nothing that prevents a part or the parties from tailoring their dispute in the manner they wish to avoid time and cost implications. But my only advice there, if they do so, they have to be aware and conscious of what they want carefully. So be careful what you wish for in this respect. And of course, keep settlement options open in a way, because no one guarantees any outcome when it goes to arbitration. And then I will end with the comment that I mentioned, which is basically, where are we going with the construction industry and the disputes related to that industry? Are we in a state of staticity or evolution? We've seen that this is a very progressive field. There is no static behavior, no static activities. It's in a constant state of flux, evolution, and metamorphosis. And that is one aspect that we need to keep in mind. Managing expectations is key. And I thought of sharing with you in bullet points important aspects there. Construction is a global leading business sector as we know it in progression. And we've seen some of the statistics and we can go on. But at least in 2020, the value of the global construction output in 2020, that when COVID was hitting, was 11.6 trillion US dollars. And the forecast is that this would increase to 14.8 trillion US dollars by 2030. And I would predict that it's going to be more. That is an increase of about 21.6%. And I'm saying it's going to be more because of the expectations, or let's say predictions, that I'm going to share with you about the field. We also see a shift from claims-oriented to a business-driven model based on collaboration rather than confrontation. People have realized that they commit so much money, energy, and resources to a fight rather than to project completion. We see a shift as well from system fragmentation to value chain integrated systems across the board in all aspects of construction projects. Project management and crisis management planning and business models are now at the forefront of looking into projects and the industry at large. Shifting towards rooting out the causes of disputes as much as possible. And this happens when more and more professionals specialize in construction and engaging experts with knowledge of the field. You gradually then eradicate the root causes for the disputes. We also see a shift that's going to take place more and more from tradition to innovation. The traditional way we do projects, the traditional way we prosecute disputes, the traditional way we decide disputes is destined for a change. And this comes as well with environmental implications, hence the shift towards decarbonizing the construction sector. And this is very important because many states, as a result of the Millennium Development Goals, and because of the climate change and the Conference of Parties in Paris and beyond, have committed to reduce carbon emissions. We've seen that the sector is responsible for no less than about 38% of the carbon emissions worldwide. Decarbonizing the construction sector is now at the forefront of what the industry is looking into and applying. And with this, I finish my final slide, which is the future trend in light of these expectations and applications that I've seen. Markets are becoming highly competitive, and construction companies are not making the profit margin they used to make before. And that is indeed challenging. So we see a very large degree of competitiveness there. I predict as well that we will have smart construction contracts. Smart contracts, blockchain is used generally, and construction is not going to be immune from that. We will also see increased use of construction drones. It is also now happening on mega projects, and robots on work sites. Now, some may think that that's a threat to the human element, and that could be indeed true, but the human element is still needed, and strongly so. But now, more than before, qualified, educated laborers are needed, not the traditional type of labor that you'd encounter. Why? Because these people are going to deal with projects, with equipment and machines that are powered by technology. So you need to have educated, trained, well-informed labor. Augmented reality and BIMs, building information modeling applications, are picking up in the construction sector. And we see that very carefully being used in smart communities and cities that are increasingly used and actually projected and constructed across the globe. Remote work sites and mobile access has become indeed a feature of the field. We've seen how COVID hit, and the ability to adapt remotely and work remotely is becoming increasingly important. And finally, construction management, artificial intelligence applications are becoming at the forefront of what the future holds. We see a lot of R&D, research and development, taken there, and even cutting its way across to disputes. Dispute avoidance policies is being applied, and with the advent of technology, with the use of artificial intelligence applications, the room for error will be at least reduced, and with the reduction in error there could be a recipe for more collaboration and less disputes. Online dispute resolution and artificial intelligence-based processes are indeed a prediction that I see as a reality, not just a hope or an expectation. It is the reality. And we have to adapt to this. And arbitration and other dispute resolution processes need to adapt to the integration of technology in dispute resolution. It's no more the situation of using emails, phones, or mobiles, or computers. It's basically dealing with many applications of multi-variable resolution optimization programs, artificial intelligence applications, document management, and to a large extent, decision-making applications in this respect. But in any event, with this, I think, despite the fact that we will have a reduction in traditional disputes, we may well have a new generation of disputes arising from smart contracts, greener buildings, augmented reality, and BIM applications. This all begs considering with due care novel practices in prosecuting arbitral proceedings with a focus on reducing time and cost. Those who want to continue to deliver services as dispute resolution practitioners and arbitrators, they need to adapt to this reality in terms of equipping themselves with the needed knowledge of what's going on globally in terms of innovation and technology to be able to deliver the service the parties are expecting. With that, I end my lecture in hope that I have provided at least something to think about, and perhaps the panel reflections could definitely contribute to this. And I'm very grateful for your patience. I hope I've not wasted your time, and I'm very much looking forward to our panel discussion. Thank you very much.
Thank you.
Thank you very much, Dr. Wahab. Thank you very, very much. You have not wasted our time at all. I thought the presentation was quite as wide as it was deep. And there's been a lot of wealth of thought-provoking information that you have brought up to the fore. You have looked at the current scenario and you have projected into the future. Now, I know Ms. Karen Goff and her panel will have a lot of interesting information to work with. But before Karen comes, I would like to inform our participants of the sponsors who have underwritten our webinar this afternoon. The webinar has been organized, as I told you, by the Jamaica International Arbitration Center, and the sponsors are Caribbean Development Bank, ADB Consultants, Jamaica Standard Products, CP Malcolm Dispute Management Practitioners, Island Blue Jamaican Mountain Coffee, Jamaican Deposit Insurance Corporation, COK Solidarity Cooperative Credit Union. And our media partner is Hype TV, local, regional, international supporting institution. And these are the persons who have supported us and kept us going. Now I'm going to be handing over to Karen and her panel. I know they have been making lots of notes. They have been listening quite carefully as to what Dr. Wahab had to say. I have a question or two, and Karen, you will just take it over and tell us just how you're going to be managing this part of the discussion. Over to you, Karen.
First of all, you haven't got to tell me to unmute. I've managed that much myself. Good afternoon, everybody. I'm Karen Goff, as it says on the papers, and I'm going to moderate the discussion, the panel discussion, which is to follow. Thank you to the JAIC for organising the event, and thanks in particular to its namesake, the lecture's namesake, Mr. Maurice Stoppy, Jamaica's special treasure, as I always think of him, of the construction industry. He lends his name to this lecture, and thank you, Maurice, for your support. It's good to see you looking so well. I would like to extend all of our very grateful thanks to Professor Mohammed Abdul Wahab for his excellent lecture and presentation. I made lots of notes, but as we were going through it, I thought, my goodness, what is it that he's going to leave us to talk about? I'm sure we will find something to talk about, but the framework that you've provided with was truly excellent. Thank you very much indeed for that. I hope that we can steal the slides away from you as well, because I think that there is food for thought in all of that information that will serve all of us very well for months, if not years to come. As I say, plenty to think and talk about now. And in the usual way, Professor, I hope you're going to join us and join the panel discussion to which we now turn. Introducing my panel, I will introduce the panel. I'll do them all at the start, but I would say to everybody that's attending, the detailed CVs of all of the speakers are already available on the JAIAC website. So I will make my introductions brief and perhaps a little more personal than what you might read on the website. I'm going to begin by introducing Suzanne Lyon-Joseph. Suzanne is a chartered surveyor who's a senior appraiser with Otto Group in the United States. Otto Group is a multidiscipline real estate appraisal and advisory firm with more than 40 years of experience providing services to a wide range of public and private clients. Suzanne is based in Manhattan, New York, so we can all be deeply envious of that, but in fact comes from Jamaica and has also spent time working in the United Kingdom. She's a graduate of Jamaica's own UTEC and a former employee of the Land Valuation Division of the Ministry of Finance in Jamaica. Suzanne took her land economy and valuation skills to the United Kingdom before heading to the United States, where she's been appraising various property types in New York and New Jersey since 2006. Successful projects are procured and delivered in accordance with their stated objectives, as we've just heard in great detail. But we can look forward to hearing from Suzanne from a property and investment appraiser's perspective. What goes into making a successful project, how to set it up, manage the finances both before, during, and at the completion of the project, maximizing profit, which is of course essential, and continuing the investment cycle as an integral part of the country's economic development. So I welcome Suzanne. My second speaker will be Mr. Robert Gerard. I'm very pleased to introduce Robert to you all. He is affectionately known in the United Kingdom as Mr. NEC, and that's for his sterling work on the drafting team of the NEC Standard Forms of Contract Documentation, which is produced by the Institute of Civil Engineers through its NEC Contract Board. Robert is a chartered surveyor, and in his practice, he sets up and manages NEC contracts. He also teaches and provides consultancy services on the use of NEC forms, which are a good example, a very good example of the collaborative form of contracting, advocated first, of course, by Sir Michael Latham in his internationally lauded report, Constructing the Team, which he published in 1994. Certainly it didn't escape me, actually, listening to Professor, that many of the issues that he was raising and many of the principles that we're discussing today, in fact, go back as far as 1994 and perhaps even before then. By way of context and relevant to today's discussion, one of the Latham report's key recommendation was a change in culture from an overly bureaucratic, wasteful, and adversarial atmosphere and practices to one centered on collaboration and partnering between the key stakeholders. I think all of that is ringing bells at this moment. Another recommendation was the increasing use by the British government of the then new NEC form of contract in government-funded projects. The NEC form was revised in 1995, having been first produced in 1993, was then revised again in 2005, and the fourth edition was produced in 2017. The ambition of the NEC was to produce a suite of contracts which encourage good management of the risks and uncertainties which are inherent in all construction projects, and to use clear and simple language in those contracts. Now, the reason I'm so delighted to welcome Robert is that he's been at the forefront of the development of the NEC forms, now, as I said, in their 4th iteration. Importantly for today, Robert is one of the authors of the NEC Dispute Resolution Services Contract 2017. I heard him contribute recently at a seminar, and he said, if you don't like that, I'm afraid that one's on me. Well, I think we do quite like it, Robert, but I think it will be interesting to hear you talk about it. That dispute resolution contract, services contract, advocates dispute avoidance, talking about the lecture again just now, and adjudication as the preferred means to avoid or resolve disputes in projects let under the NEC forms. Very much like Professor Wahab has just said, if you actually get to arbitration, you're on a losing streak. The philosophy of the NEC forms is very much in line with current thinking, as we've just heard, on the requirements for successful contracting, putting as it does the collaborative sharing of risks and reward at the heart of modern procurement in the construction industry. NEC seeks to set itself out as the benchmark for best practice procurement worldwide. So we've got Robert here with us today, and we will be very interested, I'm sure, Robert, to hear what you have to say about best practice in procurement and contracting, whether under NEC or otherwise, and its place in securing successful outcomes for construction projects. So now I turn to my third speaker, which will be Anand Jadoo. Anand is very well known to many of you, being a frequent visitor to Jamaica and the wider Caribbean, and a speaker and teacher on courses in construction management in the region, and indeed many other places elsewhere in the world. Anand is a quantity surveyor by training with legal qualifications, a chartered arbitrator and an accredited adjudicator. Anand is a highly experienced and all-round project manager, claims consultant, dispute avoidance and dispute resolution practitioner. He's always got plenty to say about the administration of contracts, about value engineering, the maintenance of cash flow, and the techniques and tools used to avoid conflict during the life of a contract. So welcome to Anand. And finally, but by no means least, my final panelist is Dr. Amma Abbas. Dr. Abbas is a partner and head of the arbitration department within the dispute resolution practice group at Matouk Bassioni in Egypt. Dr. Abbas is also a lecturer at the Faculty of Law of Cairo University, where he teaches economic legislations, that is investment law, international investment law, competition law, capital markets law, and banking. And he is the academic supervisor of the faculty's moot court arbitration. He's also an adjunct professor at the law and economic LLM program between Hamburg University and Cairo University. Dr. Abba is a registered arbitrator at the panel of arbitrators of the Egyptian Ministry of Justice, the Cairo Regional Center for International Commercial Arbitration, the Abu Dhabi Chamber of Commerce, Commercial Conciliation and Arbitration Center, and others. Dr. Abbas has acted as chairman and sole arbitrator and co-arbitrator in many arbitrations, as well as acting as a legal expert in investment treaty arbitration. Of interest, I think, to today's discussion, focusing also on the economic aspects of all of this, Dr. Abbas has worked, amongst other engagement, with the global law firm of White & Case, LLP, and also at the World Bank in Washington, DC. We look forward to Dr. Abbas's contributions this afternoon, especially in connection with his wide experience of structuring dispute resolution mechanisms to deal with the need to deter disputes in the first instance, and where they occur, to manage them through the adjudication or arbitration process. So, ladies and gentlemen, that is my esteemed panel. Suzanne, let me start with you. You're a property and investment appraiser, as we've just said. So your interest and engagement in a project begins at the very early stages of its life, really at the conception stage, starting with the idea. Can you describe briefly for us what you perceive to be the key roles of the property appraiser in bringing a project from its conception to reality, particularly in relation to the question of funding, cash flow management, and investment outcomes?
Thank you very much, Karen, and thank you to the Institute for inviting me to participate in this webinar. I feel very honored, and I must say I'm delighted to have listened to the lecture, especially in the presence of Mr. Stoppy. The value or appraisal role in the development process, as Karen has rightly says, start in most instances at inception. We are involved in not just land purchase, but often in feasibility, determining if in fact this project can realize its expected goal, not just in terms of the development, but in terms of the investment outcomes and financial gains expected by the parties involved. Development funding is very intricate, and more so here in the North American market, where there is a plethora of funding methods and equally a wide range of demands and expectations with respect to property development. There is often in the feasibility study, the feasibility determination, the initial feasibility of the project, the whole aspect of the entrepreneurial incentives and the investors, in fact, realizing their investment goals in terms of the project financing, project outcome, long-term sustainability, and stabilization of the project if the investor intends to hold it, and long-term sustainability if the investor intends to build and divest the project. Sometimes this feasibility might also be affected or impacted by the partners in the development. So quasi-government or non-profit organizations partnering and investing in developments have different goals and different expectations as opposed to the private sector investor. Even among the private sector investor, there are goals. Some investors are cash out at the end of completion, while there are investors who have long-term income desirability, which would cause them to want to hold the project, and it has impact on the funding. The appraiser's job is to essentially quantify and determine the worth of the project and the worth of that expectation at various points in time. We might be asked to determine the value of the project before construction begins. So we could be asked to determine when the project will become feasible and when, in fact, it will lose its feasibility if there are delays beyond a certain point. So the appraiser is looking not just at values today, he is also looking at values in the future based on expectations, based on government intervention, based on markets and anticipated and not anticipated changes in markets. Funding for the project usually has various aspects. There is construction funding, which might be gap funding. Gap funding means that the investor might in fact seek funding just in incremental stages. They might seek funding for the planning stage, where they are seeking approvals, variances, just trying to get their project off the ground. For example, we were working with an investor looking at a large residential development, rental housing, with the requirement that there be affordable housing units included. The inclusion of affordable housing units meant that the investor needed to get variances to increase the amount of units that he was able to produce, allowing for higher density and some other changes to the zoning regulation to ensure the feasibility of the project. Planners and public officials may often acquiesce to various variances to allow for the project to be completed, and the appraiser has to be made aware of these activities, because these activities have to be included in the appraisal process, so that the appraisal is not just looking at what the required zoning is, but is aware of any variances that may have been given that will in fact affect yield, density, and therefore affect the value of the project on completion. The appraiser in this market, even the matter of land purchase, land assembly for the project can become a very involved process, where there is the need to purchase development rights from adjoining properties or from other properties to facilitate the development. And the financing aspect of this usually is something that the appraiser is asked to look into and to become involved in terms of providing value for a value opinion for these various aspects. I should point out that we are always, as appraisers, at pains to point out the distinction between cost and value, because in a lot of instances and in some finance markets, financing is provided based on the cost. In other markets and with other projects, the financing is based on value, and cost has to be a part of that value consideration. So the cost of the project is accounted for in looking at the value of the project, especially if the appraiser is asked to look at the value of the project as at completion and as at stabilization, which is when the project is in fact fully marketable or has reached its optimum in terms of income generation.
So, Suzanne?
Yes.
Could I just ask you briefly, what is the key, in your view, to managing asset owner expectations during the early stages of the project? You've heard that this is one of the things that is a serious contributing factor to disputes as things go on. Is there some special mechanism that you deploy right at the outside to try and manage these expectations?
A lot of communication. The appraiser demands that they be kept informed with respect to all changes in relation to the project. It is the appraiser's job to be aware of governmental changes that might affect aspects that, for example, real property taxes, tax assessment, financing, any kind of input that could affect. But being aware, there are developers who think that the appraiser doesn't need to know about the construction aspect, but it's very important that we are made aware of all the aspects relating to the construction. Contingencies, what are those contingencies for? What time gaps are the project members expecting that they have taken into account? Because if those time gaps are inadequate, let's say, then the appraiser needs to be aware and needs to also consider those kinds of aspects. So communication is very, very important. When there are changes, it's important, especially if the appraiser is involved in phased financing. It's important that the appraiser is aware of changes and can, in fact, factor those changes in terms of the impact they'll have. The other aspect that is important or key to managing is always the aspect of the investor's return on their investment and what it is that they expect, what they considered to have been a feasible return when they got involved in the project, and making them aware of anything that might in fact impact those returns as the project progresses, so that the investor is aware of essentially what is happening to value and therefore what is happening to his money as the project proceeds.
Okay, thank you, Suzanne. And Anne, do you want to add anything to that? Obviously, your involvement comes at a later stage in the project, but during the life of the project, you're obviously concerned with the management of time and money and quality as the project goes along. What would you say would be the key to manage owner expectations as the project goes along?
Thank you, Karen. Also, thank you to JISC and Christopher Malcolm for inviting me for this prestigious Maurice Toppy coffee talk, as I call it, coffee time. And so taking on from what Karen, what Mohammed Al-Wahab, Professor Mohammed Al-Wahab has said about value chain economics, I think there's a lot of, it's given the pandemic that we're going through, it has actually opened up the world to sort of take stocks of what was happening before and what we need to look for the future. So I would add that, first of all, there is this value chain management, which is recognized as a contemporary concept that improves the organizational efficiency in construction by sustaining and enhancing the competitive advantage of all participating firms in production process to save project cost and add project value. Of course, it is evident that these principles and methodology of value management are not only necessary in construction projects to achieve better value from resources, but also to deliver ancillary benefits such as better communication, like Suzanne mentioned, improved team working, better alignment of the supply chain, and objectives. So in terms of value chain economics, there are 5 main activities within the construction industry. One would be the raw materials. Yes.
Can I just bring you back to my question, which was in relation to during the course of the project and managing owners' expectations during the course of your construction management? Oh, just shifted from one screen to the other. I will go back to the question in a minute, but I just wanted to sort of round off with your view of what Suzanne was talking about, but from a later stage in contracting process.
Okay, so of course you would be having the procurement aspects in terms of, as Mohammed just mentioned, is choosing the right procurement process. And this is where, after that, you probably have the role, the contract administrator, be it the engineer, architect, project manager, has a very crucial role to play during the construction process. And that's where the project management, value engineering, and dispute avoidance comes into play in terms of, project management. And in that particular aspect, I would add, and Mohammed just mentioned that earlier, and you also mentioned in terms of the Latin report, construction, collaboration and partnering, and also a shift towards innovation. And I believe the contract administrator has a very major role to play. And in this difficult times, parties actually should explore collaborative contracting within the project management aspects of construction. It should adopt a collaborative framework agreement, ensure early contractors' involvement and other collaborative procurement actors, as we call it, establish a joint decision-making body to discuss, in fact, about financing, leading on from in terms of what amount of money from feasibility aspects have put forward, allow contractors to participate or collaborate in the design process, ensure that the project is buildable, ensure also that there is shared risk, such as delay risk or rectification works whenever there's something wrong in it. But there must be also transparency through open book contracting. And as Susan mentioned, there is a I think it's very important that there should be effective communication. In fact, construction projects rely on effective communication between the contractors and the employer's team to succeed. If people work as a team, in fact, most problems can be solved. So, which leads me next to the point of value engineering. In fact, value engineering is a sound basis for choosing effective options. It can provide insights into functions required and the means of providing them. Of course, it does eliminate unnecessary cost, which does not contribute to the level of performance. It improves buildability. It improves performance and value. In short, it provides value for money construction. So value engineering, in fact, does not stop or doesn't start or stop at feasibility stage. It goes on from the inception of a project and goes right through the construction phase, where the contractor may also have a significant contribution to make, as long as the changes required to the contract do not affect the timescale, completion dates, or incur additional costs that outweigh the savings. So this is achieved, in fact. Yeah.
In terms of value engineering, isn't the most advantageous time to actually look at value engineering in a project at the start of the project? I mean, there are certain risks around introducing value engineering. I mean, most of the big standard form contracts actually allow for it, but there are always risks around bringing it in at a later stage, are there not? How are those risks to be managed without causing disruption to the project and upsetting all of the goals that Suzanne was talking about just now?
Karen, there is what we call, in fact, as I said to you, the value engineering should start from project inception. But normally when an architect is actually working on the project at project inception, he has his own value, he has his own mind and so on, and he designs to what he thinks is the best design that would suit the project, but not necessarily the cost. And when you have the feasibility studies, which bring in a certain sort of, parameters in terms of value, where do you shift from there? And that's where value engineering comes in and can be beneficial to look at various packages, such as, for example, piling, in terms of different type of piling, or in terms of different types of foundations, whether a piling foundation is good enough, or a deep foundation, or what we call retaining walls, etc. But all these have different costs. So it starts from inception, but it just follows through right through the construction phase. It doesn't stop at inception stage at all, or initial stage. It goes through right to the construction process, and even right at the end. Because what you are looking at is a product. Is a product, if you construct a cheap project, let's say, to a very tight budget, of course, there will be cutting corners, etc., etc. But what happens after the project is completed? You will, both the owners and the occupiers will be faced with a lot of problems in terms of management of the finished product. There will be a lot of defects, etc., etc., that will manifest. So, at the end of the day, project value engineering offers a lot of possibilities. In fact, it identifies items that can be omitted from the inception stage, identify items that can have the specifications change in terms of value and in terms of enhanced specification, identify items that could be reinstigated later in the program if the budget allows, identify enabling works that can be incorporated in the design, allowing elements to be added during later phase of construction. The client and of course the full consultant team should take part, along with the contractor, the construction manager, the contract administrator, and a management contractor if appointed. So intention of this provision is to encourage contractors to apply their knowledge and experience the benefits of both themselves and the developer or employer. So it may benefit, in fact, because its cost of production are reduced, but the employer receives a product which is as good as that originally designed. So in fact, Karen, you're looking at a continuous process in terms of value engineering.
Yes, I see that, Anand. But alongside the possible benefits of value engineering, certainly once the contract has started, once the works are ongoing, are some serious potential risks in the project, in terms of time, in terms of delay, in terms of productivity. There are a lot of risks around value engineering during the life of a project, and many times I've dealt with disputes where one of the holdups has been a late idea that's said to be advanced under the name of value engineering, which has been in fact hugely disruptive. But we can come back to that. I actually would like to go to Robert and turn back. Robert, we all understand, I hope, I've explained the role you've played in developing collaborative contracting models and partnering in the construction industry in the UK and indeed much further afield. You're now based in Hong Kong. In the professor's lecture at point number 5 in his lecture, he referred to human behavior. And I know that you have on more than one occasion cited human behavior as one of the great difficulties for contracting in the construction industry. I'd like to ask you what you see as the key behavioral obstacles to successful contracting. What are the features of successful risk management in contracting, dealing with time and quality and money issues successfully also in the drafting of the contracts and setting up project management systems, of which, of course, you have a lifetime almost of experience. Perhaps we could have your take on those points.
Okay, that was a big question, but okay, let me try. So apologies for the darkness. What time is it now? 05:49 in the morning. I think I set the alarm for 03:50. I did watch the second half of the European football game, so all is not lost. Yeah, and very good it was. So yeah, Karen over-eggs me a little bit, but I'm very grateful to contribute here today. I think it's very important to set out, as you're doing here, to constantly improve our industry in a very ethical way. So I'm a chartered QS, I'm an accredited mediator. I try and focus on dispute avoidance, not dispute resolution. But these days, I think at the heart of your question, I would call myself a contract manager, and I question quite how many people actually have the skills necessary to manage a contract. I think we tend to administer contracts. We have a reactive wait and see approach to contracts all too often, rather than a proactive foresight-based contract management approach. So I have drafted parts of NEC4 contracts. I did the redraft of options W1, W2, and W3, which is the NEC avoidance and resolution dispute clauses. I do think as an industry, we get lots of things right. We've heard of quite a lot of negativity, if you like, but we get a lot of things right, don't we? We get a lot of things wrong, but I live in a truly amazing place, which is Hong Kong, and the size of a postage stamp. There's the most incredible buildings and infrastructure here. So I think we've heard of an array of issues that lead to disputes arising, but I think the heart of all of that, really the direct answer, is that it's about attitude and mindset. I think we need to recalibrate it. It's almost like a re-engineering process. Go in and so just a couple of wires that are loose usually in people's brains that we need to recalibrate people to have the right attitude and mindset at all times. So I think we need to realize that individuals, people are put under tremendous pressure, stresses and strains from disputes, and never underestimate the human cost to disputes themselves. And I think we are generally pretty intelligent people, but our intelligence is often misdirected towards self-interest or corporate interests, rather than acting collaboratively in the interests of the project. So I think you should, again, in answering that question, remember that procurement is all about alignment of objectives. That is what we're striving for in procurement. We're trying to align the objectives of the parties. So we need things like, Suzanne touched upon this, we need a sound business case. We need to move away from lowest price mentality, which can be okay on occasion. And most importantly, we need to produce what I would call brilliant tender documents. Have I ever seen a good set of tender documents? No. Do lots of reviews of tender documents. They're appalling, absolutely appalling by and large. So we have to drastically improve the starting point. We talked about value engineering. I have a real problem with value engineering. To me, it shouldn't exist. It should be that the designer's job is to produce the optimum design. I cannot see how you do it one way and then it's, oh, but I could do it a different way and it'd be much better. Your job is to do the optimum design. You are ethically employed to reach that optimum design. It's not a bolt-on chargeable extra. I think we need to think about using those modern forms of contracts such as NEC4. We need to get people doing more of the right thing more of the time. We need to move away from those comfort blanket provisions that we constantly put into contracts, like retention and liquidated damages and a performance bond and a parent company guarantee. And why we put every company on their knees in terms of negative cash flow is completely beyond me. So turn those things over. Look at things like advance payment, early contractor involvement, key performance indicators, the use of open book target cost contracting. And then once we set the contract up, so set the contract up mindset needs to be right to achieve the needs and interests of the parties to a contract. And then once you've set that contract up in that way, learn how to actually deliver it. You know, to me, the contract management should be just about delivery. All the intelligence goes to setting things up. We then press that button and go deliver. I do agree that often it is too late to start thinking about value engineering once you're in contract, which is the beauty to me of ECI, is using your combined intelligence to set up a great scope for a fine price, you know, put your tender documents together, you know, very intelligently, and then press the sort of go button, the notice to proceed, move into stage 2 and deliver it. And very interesting behavior. So where I work live and work in Hong Kong, the use of NEC is mandated by the government here deliberately to bring about positive change in culture. So I don't think we're about beating ourselves up too much. It's a little bit of recalibration of our attitude and mindset, and have problem-solving, dispute avoidance hats on rather than revert to time. And all of this is about culture, isn't it? It's basically about culture, and it's, you know, a challenge, but by no means beyond us. That was a long answer to a long question.
But it was a good answer all the same. So thanks for that. Mohammed, I see you sort of hovering there. Do you want to say something at this point?
Well, a couple of points, actually. I mean, I've been following the discussion, very insightful. And I must say, Robert really took something off my lips I was going to say with value engineering, because it was very interesting. And, you know, of course, you've got the reactive, the proactive value engineering, and I always grappled with the idea. Should they not do the work in the most effective way, as exactly Robert has mentioned? But then in reality, I came across the following point. To do this, you need to invest time and cost in brainstorming, looking at options, trying, finding ways. Sometimes this is a luxury that clients may not wish to engage in because they are not sure whether this will yield the intended outcome or not. So people, instead of being innovative, they just don't want to reinvent the wheel. They will do the same thing the way they do it, which leads to the situation that, you know, progression becomes problematic. But the thing is, and I was looking at statistics some time ago, a year ago, when I was looking at value engineering, and I discovered that there is out there, seems to be evidence that if you invest, let's say $1 in value engineering, effectively the return on this investment is 10 times. So I think more work needs to be done to show people that investing in value engineering should be normative to reach the outcome that you wish to reach, because the yield or the return on that is by far better. So, I mean, these are my just 2 cents on the topic, but I think it's a very important aspect that we need to reconsider when it comes to construction.
Yeah, I think you're obviously right. I mean, I jumped on Anand, poor man, and said, well, hang on a minute, you can't go value engineering in the middle of projects because it just causes trouble. But in fact, I mean, the point about it is right. But the point that we all seem to be making is that value engineering at the outset, part of the initial investment, it is more than worth its money. Amir, I haven't heard from you yet. What do you say about this?
I think it's very important to start thinking from the beginning about how to identify the main points, the main specification appropriate to the specific project and the parties. And this is mainly, when I look at it, it starts from the inception, from the owner, from the architect, from the bidding process. All of this is very important to start from the beginning. Defining roles in the contract itself and the responsibilities, clearly defining the scope of work, clearly defining the payment terms, and the clauses regarding the monitoring, the progress, and the update of the program schedule. All of these are to start from the beginning, early on. going for where the disputes happen. Disputes are inevitable, actually, in construction. So Professor Abou Wahab was just explaining all of these issues, complex relationships, and different parties, different contracts, and in this whole chain for having a construction project. Add to this the bidding process, low prices, and then trying to compensate this by raising claims. So again, from the beginning, focusing on defining the roles and clearly defining the scope. Also, the very important point that was raised by Professor Abou Wahab is the whole, what he called equilibrium in the contract. It's fundamental. That to have reasonable time for completion, to have reasonable liquidated damages, to have the critical path method for scheduling. All of these, like, we can go one by one and to explain. It's very important. Another very important part is time, which is a fundamental importance in construction, and which time is of essence or very fundamental in construction. So having a reasonable time for the completion is very important. Also, the documentation and the from the beginning for all the construction delay claim management, implementing a delay claim documentation and prevention program starting from the beginning is very important. So if we start from a contract completion date being a reasonable one, having the frame that is reasonable for all parties. Also, another point of having the critical path method, which is to have the specifications. This would reduce significantly the delay claims, and having all parties involved in this and cooperation, the whole thing of cooperating into the system and having the input of everyone in the detailed of the critical path method, and having the contractor, the key subcontractors, and the key suppliers having input in the preparation of the CPM, R diagram, and related narrative reports. Also, the very important is in the agreement also to have the notice provisions being specified, how the proper notice is relative to today's time frames, and the content of all notice requirements highlighted, requiring acknowledgement from the owner or the contractor, depending on this, and trying to reach a response within a proper time frame to solve these in a proper time. Also specifying the excusable, given the delay is almost inevitable in many projects, and having, for all the circumstances that happen, so having what are the excusable delays and having more specifications when it comes to the example of the weather and the changes. Even the weather, there could be, I've seen problems and disputes happening because dispute about whether the weather was actually excusable delay or not, and what kind of weather that excuses delay, the details of the severity of the weather, the definition of the number of the days per month for the severity which is foreseeable. All of these has to be specified in the contract. Force majeure clauses should contain all the specific criteria in relation to the force majeure events. Who will bear this, and what would be the result of the excusable delay in terms of time extension, costs, and others. these are also things to think of. Time frame for delay claim resolution. The contract clause should require that the delay claim be addressed immediately, critical path message be updated, and timely submission and review process should be implemented. Also, the thing that was mentioned regarding the contract drawings and carefully preparing the drawings and at the various stages of the and trying to avoid errors. And there is always a debate whether the contractor should have a say or should be reviewing in the have a sign-offs or not, and the effect of this on the engineer and who would be the responsible for the design errors is a debatable thing. Another, I think, very important thing for dispute resolution is the dispute boards and the role of dispute boards. Dispute boards are important. They are different from mediation and what Dr. Salah Abdulwahab was saying regarding the being a surgery, going to arbitration. In fact, having dispute boards is convened from the very beginning of the project, conducting the meetings, regular meetings, coming and visiting, discussing the progress and monitoring the construction. All of these meetings with all parties involved, including subcontractors and suppliers. This can have effect in encouraging the open discussion between the parties, cooperation, and also gives the representatives of the owners the ability to avoid claims by having the dispute board involved and relying on their recommendations and interference. The importance of dispute boards also comes because they affect the future behavior of the parties. When you go to arbitration or mediation, litigation, this looks back, but for dispute board involvement, it looks to the future.
Can I just pause you there for a moment?
Sure.
Come back to the dispute board, because I think that is an important and really quite a big and discrete subject. I mean, I think taking what you said at the beginning, you were talking about documentation and the sufficiency of documentation, and you made a number of excellent points, I think, about the causes of disputes. And we saw from Mohammed's lecture, he actually gave us a nice potted little slide dealing with many of the causes of dispute, but actually an awful lot of them can be tracked back to problems with the initial documentation, the initial setting up of the contract. And I think, in fact, that is what you were just actually going through. And one of the issues as well is not just the bidding documents and the design and all the other component parts of that, but the contract terms themselves, which you, Amma, were just talking about. And that too is interesting. And I think I'd like to flip back to Robert on this, because you know, we're looking at imbalances in contract documents and inappropriate allocation and sharing of risks as being issues which are just endemic in construction contracts. And Robert, I'm actually looking at the chat and you asked me a question. Can I take you back to the point you wanted to make before we then go on to our disputes, but also picking up on this question of inappropriate bidding documents, inappropriate allocation of risks in the contract terms and conditions themselves. How do you suggest that those issues are dealt with?
I wish that contractors would truly price the risks that they take on board. Who would be a contractor? You sign up to provide the works in accordance with the scope. You read the scope, you read the contract conditions. And honestly, what a crazy industry. You know, most contractors these days, certainly civil engineering, you know, daren't even put 1% of monies in for profit. I can't think of another industry that exposes, you know, an incredible amount of legacy on one particular project where they could lose everything. They could lose their shirt. It's crazy. There is not, I don't particularly want, what am I trying to say? I don't want them to price it. I think I'd rather see more sensible and reasonable terms and conditions in the first place. But if push comes to shove, you should price the document in front of you, warts and all. And I think there should be considerable amounts of money put in for risk and more than reasonable amounts of money for profit. It's one number crazy industry. And I honestly don't believe that clients realize the extent of the risk that is put upon the contracting industry. And you can look at things like alternative bids. I've done this before, where we say to a contractor, actually paid up front on one job, it's a lump sum contract, this, but if we chose to pay up front, would there be a discount? And I've done this on 2 jobs. One contractor said, yep, you can have 5% discount. Another one said 7% discount. Both of those were lump sum contracts, and both were secured with a bond in case of, running off to a nice place like the Caribbean with the client's money and never coming back. So do we truly understand the cost of risk transfer? I don't think we do. So we need to educate ourselves and find out just how expensive that is, just what pressure that puts upon clients. Even things like performance bonds are quite innocuous, aren't they? And I can remember being told very first tender documents, you must include a performance bond. Why? Because we always have one. Why? Why is a really annoying question. Ask it 3 times and you get the truth, but nobody can answer why. Why? Because we like to sleep well at night. That's why. So Karen's point about unreasonable terms is because we're used to them, because we like to sleep well at night, knowing that in the morning, if the world's a different place, the client should be well served. But even a 10% performance bond costs nearly 2% of the whole tender total. That's crazy money. That is crazy. Save your 2% as a client. I was going to say put it in a bank. Probably don't trust banks, but I don't say that public. I don't know. But put it under your mattress. Save up all those 2%. Give half of it to charity. Don't waste the opportunities that you have. Life is too short. Look at different ways of procuring. Take out some of that, unnecessary risk transfer. Educate yourself. Act like an adult. But as a contractor, if if push comes to shove, price it accordingly. Please price risk. Please add in reasonable amounts of profit. This is one number crazy race to the bottom industry. Not acceptable, not sustainable. We want to attract future people to it, don't we? We want to create a fantastic legacy of an industry that is safe, that is enjoyable, that is rewarding, that is profitable, that leads to investment, and investment will allow contractors to improve the quality and the ability of their people. So it's a self-defeating, prophecy to pack contracts with crazy terms and conditions.
Yeah, I think we all realize actually that inappropriate and unrealistic budgets, costings, and programs are the cause of a huge number of disputes.
Yeah.
Suzanne, what do you think about what Robert just said about park the bonds, park the retention? How do you think that your funders and asset owners would respond to those circumstances? What do you think of the prospects of altering the risk-averse culture of the investors in the construction industry?
Well, I found I was enjoying a lot of what Robert was saying in terms of the race to the bottom, as most contractors, and the fact that they actually bear a lot of the risks. But it's a known fact that most contractors price low in the hope that as the job continues, there will be reason to go over budget or to find the correct pricing of the job. But Robert mentioned something about being efficient and starting with the term he used, the optimum design. And I found myself thinking, optimum design, who defines optimum? Because if the optimum design is based on the planning position, it might not be a feasible project. Or if it's based on the investor's position, it might be a desirable project, but still not feasible. I think what happens is that we always try to find a happy medium or the place that will get the project going to deal with the issues that may arise as they arise, which of course leads to disputes and the need for dispute resolution. The matter of proper planning, value engineering, brainstorming, I think the initial stage, planning and development, working out the kinks, as much as they can be foreseen or they are known, is one of the best places to start to avoid a lot of the disputes. If the expectations are clearly defined, both in terms of the contract and at the initial planning stage, I think there is less reason for dispute. And if there's ongoing communication, it certainly will address most of the problems.
Thanks for that, Suzanne. Anand, I cut you dead in the middle, and boy, you set a hair running with your value engineering point.
No, that's all right. Sorry?
Would you like to come back and add something to what you were saying?
On the value engineering?
Or whatever you like. And we've moved on a little bit from there.
Well,
but
you know, I would actually go along with what Robert has just mentioned. It is really crazy from the employer to think that the contractor has got a large back, so let's put everything in the document, irrespective whether it makes sense or not. But the guy is a contractor, so he should be able to do it. Construct whatever you want at what price at a price that you would probably do it, without even, for example, I've seen documents which involves, in fact, heavy engineering, soil mechanics, and so on. But there is no soil investigation. And there they say, okay, you can, we give you like a visit to the site, and you go along, and then if you price it, you will not be able to actually come back and say, because of the different soil conditions that you didn't foresee, you will have to bear the cost. Now, in what world are we living? Is that world of contracting? Of course not. So it is clear that there is to be, like, the clients as well as contractors. I mean, look, contractors' jobs is to construct, of course, is to make profit. But how can you ask them to make things which they can't foresee? I mean, who could actually foresee that, let's say, freight cost has gone up more than 200%, 300% in a matter of 2 years? So it's crazy just telling them. I mean, Robert was mentioning about this issue of performance bond. Add to that advance payment guarantee, insurances, all that eats up about 7%, approximately 7% of the construction cost. Now, plus on top of that, you're piling on all those risks, which the contractor obviously has to price. Plus on top of that, he has to price, and he does include some cost for certain liquidated damages that he knows that he will have to pay at the end of the day. So in fact, what the client ends up with? He ends up with a project that is really expensive, that could have been through a collaboration, as I said earlier, or through some let's say, frank discussions, look at the design. What, the contractor is there to build. He is, in fact, expert in construction. Bring him on board. Let him use his skills. But you are, let's say, good in financing. Provide that financing aspect. Share the risk. Open book. Discuss. Communication. Things will work out, and you will get a cheaper cheaper project, maybe at a better quality. Right now, the contractor is in a fix. He knows that he has to get out. He has priced at a very low rate. Where the hell do you think he will make profit? Is by cutting corners. And that's a big, big problem. Over to you, Karen.
Thank you very much, Anand. Yeah, that was really insightful. It seems to me that we all seem to be pretty much on the same page. I want to move on to dispute avoidance, dispute resolution. We've touched on it already a little bit, and perhaps I could start with Amir, because I cut you off when you began your comments on that subject. And I wanted to ask you, Amir, how you approach the structuring of dispute avoidance and dispute resolution mechanisms in contracts, i.e. how you promote dispute avoidance and reduce the incidences of dispute. What would be your advice to the attendees on that subject?
So, yes, I think the beginning would be very much appropriate clauses for the parties, appropriate scope, very clear scope for the rules, and having reasonable conditions. All what we have just heard, that we have almost a problem, that is that there is unreasonability of placing a lot of the burden on one party, which is the main contractor, and sometimes this cascades to the subcontractor. So this is very important. The second thing is having perhaps what's called dispute board, which is involved from the beginning. They are chosen from a panel that should be neutral and are experts that come and visit. And from the early beginning, they come and visit the sites. They deal with everyone. They deal with the problem. They can give recommendations. They can have sometimes binding recommendations. They allow all the parties to exchange their opinions, and then they can give advice. They can elicit cooperation from all stakeholders. This is one thing that can be very important and can help in avoiding disputes or solving them early on and not leaving them till the end or after that. Another thing is we have the issue of the different parties involved. No one contractor normally is able to do all the work. They always have subcontractors, and aligning these contracts together, the main contract and all the subcontractors through different methods, is very important. Another challenge that we have all these kind of good proposals regarding having joint proceedings for the disputes, which very rarely that happens, is trying to reach a way that disputes that are interrelated issues, because you have several contracts, but sometimes the disputes arise under one contract but related to other contracts with other parties. Whether we have solution with consolidation, joinder, or an umbrella clause for dispute resolution, this is also another way to think ahead. Documentation for sure is very important from the inception, all the time, because in the main point of delays and all delays, it has to start from the beginning to have documentation and proper communication of all the documentation, and the claims made and the review of the claims are made early on and contemporaneously with the events. I think these are more or less the main points.
So, Amir, I don't think that anybody in the room would argue as a matter of principle that standing dispute boards on major projects are a really healthy device for avoiding disputes and getting parties around table and sorting out issues before they get to antsy, if I can put it that way. But what I want to ask each of you in turn, I think, is why is it that when you have that common understanding and agreement about the value of dispute boards, and almost all of the major contract forms now provide for dispute adjudication and avoidance boards, or whatever they call them, why is it that parties still are reluctant to engage in the dispute avoidance and adjudication process as they are? I mean, I was listening to a speaker in Singapore the other day. They're not popular in Asia. They're not popular in the Middle East. They are, in fact, not much used in the UK. And Robert will know that the JCT in the UK has just brought in a new, what do they call it? The DAB documentation, where in fact they establish dispute adjudication boards. But parties seem reluctant to engage in them. Why do you think that is? Is that a behavioral thing? Is it a genuinely cost issue? What's the issue? Professor, you arbitrate all over the world, so you see these problems because they get to you because they haven't been through the dispute board. What do you think the issue is?
I'll tell you candidly for others to share their views as well. First of all, enforceability issues. You don't have a degree of enforceability assurances like arbitral awards when it comes to dispute boards decisions. That's one thing. Secondly, and speaking to business people on both sides, employer and the contractor, and that's a psychological element, perhaps in certain parts of the world, is that they feel that if the dispute goes to the dispute board, it is destined to go to arbitration. So let's cut it short, save everyone's time, and take a sort of a short circuit, the whole process, and go there. And even with those who genuinely believe, as one would expect and hope, that dispute boards would work, the issue is, with the first couple of decisions that are against one of the parties, they flip and turn around the table. They don't want to continue the process, and they will find ways to obstruct it in a way. And because, it doesn't work for them. So because of all these things, and because they know ultimately there is an escalation going there, and because of the lack of trust and confidence, once the dispute hits the board or elsewhere, they realize that every party now is writing a communication with the intention to create evidence, self-serving in a way, one way or the other. So this breach of trust and absence of cooperation, in a way, creates this loophole and this vicious circle. That's why you end up in that situation. Though I have seen in situations, rare though, that the parties have put in their contracts provisions saying that the dispute board findings would be binding and the tribunal would not reverse them, save in cases of fraud or addressing matters that are manifestly within the legal realm one way or the other. And so as lawyers would enjoy, as you would know, Karen, the interpretation and the debate and the dispute about what would manifestly be and whether it exceeded the jurisdiction and whether there is fraud or not. And you have a whole case about side issues that are not really addressing the whole merits of the dispute. So that's where we are. That's the problem.
You're quite right. We have enormous fun with statutory adjudication in the UK on precisely all of those grounds you've just mentioned. Suzanne, clients, investors, what do they think about dispute boards? Do you have a view on that? You're on mute.
Sorry, I don't have much of a view. The disputes that face the appraiser is usually dealt with the appraisal board, and those are already established and by law have their criteria. There is usually discussions before disputes. So the client and the investor will approach the appraiser with their issues, and there will be open and frank discussions. it usually ends up with the appraisal board if in fact the desire of the parties cannot be reasonably or ethically met, and therefore they decide to take it all the way to that body for arbitration and resolution.
Okay, thanks. Anand.
You know, in terms of disputes, for the disputes which I've been involved in, as far as DAB is concerned, sorry, can you hear me now?
Yes.
I seem to be hearing voices coming out. Okay. You know, the DABs that have been involved either as counsel or as the chairman of the board or even as adjudicator has been quite, you know, experienced in certain manner, that 60% of that, the findings is accepted by the employer and they do pay, they abide by it and so on. The other 40% try and negotiate and say, okay, fine, let's not go to arbitration, but we will pay you so much less, etc., etc. And, you know, both parties are in fact in a problem, in a fix, whereby if they assess their risk of taking the matter further to arbitration, for them, the cost of arbitration, especially in this part of the world, I mean, Mauritius and Eastern Africa, is really expensive. Arbitration is becoming, in fact, more expensive than adjudication, and also than courts. And I see many parties, in fact, instead of going to arbitration, go directly to the courts because it takes less time and is cheaper, which is good for them. But my experience of DAB, as just to say the least, is that enough in terms of you know, if the parties believe that they have either genuinely won or they've lost, they don't want to spend any more money and say, all right, let's settle it. But you see other parties in terms of the big powerhouse, as I call big contractors or big employers, they are willing to spend the money. But in general terms, especially when you see FIDIC contracts, whereby it says, look, okay, fine, you got, as what Mohammed was saying, that whether you like it or not, it becomes final and binding. If you want to take it further or dispute the matter to the arbitration and so on, well, settle the bill first and then you can dispute later. Pay now and argue later, as you would see in the UK. So that's the way it goes here.
What about the issues that were outlined by the professor? I mean, do you share those experiences? Oh, there you are.
Well, I have just to, I have actually experienced what the professor was saying. And I do feel for the contractors, because you know that nowadays, especially the small contractors, cannot bring their disputes forward at all because it's, one, it's too expensive. Secondly, they don't have enough money to actually fund the adjudicator or the board itself. And if you see what's going on today, is that no one, as you rightly mentioned, no one wants a standing DAB. First of all, because it's so costly. Secondly, they don't trust the people and they try and bring people overseas, which is much more costly as well. And it's hardly ever used, because if you bring the DAB into the picture, the cost goes up as well. So it's a catch-22 situation. That's the problem that you face here.
I think there is an educational issue when people talk about costs, though, because actually the cost of a standing DAB is really a fraction of the contract price. And if they actually achieve the objective that they have, which is to avoid costly disputes, then they're worth their weight in gold. But I mean, the reality is people just don't see that. Robert, what do you say about it?
Interesting subject area, isn't it? So, I mean, adjudication is quite different to dispute boards, but dispute boards in themselves, people don't actually understand them. So I drafted the DAB provisions in W3 of NEC, but that's a dispute avoidance board. We have dispute adjudication boards. We have dispute boards. We have dispute resolution advisors. We have, all different things. Some of them make decisions. Some of them don't. Our emphasis in W3 is about nipping potential disputes in the bud, giving advice to stop those potential disputes becoming disputes, so that early engagement of wise people to help avert a formal dispute. The jury's out for me in dispute boards, although I am a dispute board for a large project here, and only yesterday I emailed both parties separately because they seem to like that for some reason. Misses the point of the board, but never mind. And I said, hi, haven't heard from you in 3 months. How's it going? Would you like to avail yourself of my services? And I think I'm seen as they don't want me there. Generally they don't want disputes, but they don't actually want me there. I don't think it's a personal thing against me, but I think it's a sign of failure if we have to go to the board that we've failed. And I actually quite like that way of thinking. So I think, go back to what this is all about. If we set things up properly in the first place and have the right contracts for the right price and the right terms and conditions, and we act ethically and morally, and we do things properly, then we should be able to avoid these sort of disputes. But I think the biggest problem is that there are not enough good negotiators in our industry, and most of us do not understand how fantastic mediation is. So what I would do is put efforts into educating people on the beauty of mediation and how to negotiate. In fact, in the Philippines, I was told they're actually teaching school children how to mediate, which I find absolutely fascinating. And what they're saying is, when there's a problem, don't punch the other person or don't sue them. Try and resolve it amicably. And I love the thought of whatever size projects that when things go wrong, that we speak openly and responsibly together, and we seek to establish each other's needs and interests, and we set about trying to nip problems in the bud. We can sort these problems out ourselves. So yeah, I am a mediator and a board member, but I hope my services are never ever required. Not that I'm necessarily bad at them, but I want people to sort these things out for themselves, set things up to succeed in the first place. But should things go wrong, have the skills and the ability to negotiate and to mediate and sort things out yourselves, and not give it to a crusty old soul like me who gets paid too much money per hour to be a board member.
Well, I'm sure we all feel desperately sorry for you. But what I really want
I don't earn any money. I don't earn any.
What I wanted to ask you, and I don't know whether you've got any figures at the figures at the tips of your fingers, is do you have any information about the take-up of the W3 option in NEC4? Because I couldn't see any empirical evidence anywhere. I was writing about it the other day, and I thought, well, NEC have got this dispute avoidance provision. FIDIC 2017, dispute avoidance and adjudication provisions. Now we've got the JCT with a dispute avoidance, or if you don't avoid, adjudication provision, and we'll see how that goes. But what's the take-up?
Who's using it? I don't know.
Using it?
I don't know anybody that's using it, but most clients have their own dispute escalation process. And only on the mega projects do they seem to have, certainly here in Hong Kong, they prolifically use dispute, they call it DRAs, dispute resolution advisor. So they're not going to use W3, they're going to use their own equivalent DRA provision. So they already have things in place. So I think we're a little bit late to the party with W3, if I'm honest. And lots of these large projects already have similar sort of provisions. I don't know anybody that's using proper DAB the way in which we intended it to be used. How about that? 0, 0, nothing.
There you go. Amma, I want to give you a last moment, and then we've got a question in the chat from Dean, actually. which I will throw to you all. So Amma, just briefly, what's your take on it? What's your experience?
Well, I have seen it work actually, and I've seen it's big projects, that's for sure, but I've seen it work, or at least it became either a basis for settling, or people accept it and continue. So I think it's the problem, as everyone said, Professor Abu Wahab and everyone, is that there is an issue of trust. There is an issue always of that this could lead to a dispute. We will not stop here, but we will lead, and then everyone is not cooperating. But I think in many instances, this idea, whether it's whatever the dispute board type is very is worth trying, and it's worth educating everyone about it and using. That would be my last.
Okay, well, thanks very much. So let me just pick up this question from the chat. So if construction costs are presumed below real costs, should investors look to innovative financing of construction development and innovative means of purchasing the product? And then he says, I've assumed that purchasers are already challenged in affording real estate. Do you want me to repeat that? No?
No.
No, right, if you, Suzanne?
Certainly in this market, there are, as I said before, a plethora of funding options. And we have seen investors who have become very innovative. They have married grant funds with bank funds, with family money, with small investments. There are various ways in which projects are funded. I remember one developer actually did part of the construction himself just to reduce costs. So he became the contractor on the project, procuring items by all means possible. Very innovative in terms of some of the fittings and that was used, some of the plumbing that was used, because he fabricated his own bathtubs, and they will do whatever is necessary to get the project completed once, especially if it runs into problems with funding and they have exhausted all the conventional means. Beyond that, I still contend that there is a need for proper pricing in the initial stage, proper management in terms of expectations to take the project forward. Some investors actually start their project already knowing that they are short on funds, and therefore the need for innovative funding is, as it were, baked in the cake, because they know that they'll have to find some means of funding to complete the project since they have already started at a shortfall.
That is increasingly the project with certainly public procurement projects, and you see that everywhere, don't you? Thank you, Suzanne. That's a really good answer. Okay, we're just about out of time on our questions and answers. I want to go back to the professor's lecture and his conclusion, and he put up the challenge. He said, will the construction industry be static? Will it live on in its old behavioral way, or will there be evolution? So can I just go through you all and literally in a sentence, tell me what you think is the answer? Professor, you posed the question. What's your answer?
There will be, I'm be biased for this. Well, my immediate answer, it can't continue as is. I think it will have to evolve, it will have to change. And part of the change would be in response to the increasing challenges and problems. I mean, look at the last question, for example. I've seen situations where the investors or the developers, because they don't have enough money, they have specifically went after contractors who have money and would expect them to fund the works when they have a shortfall. And then when things fell through, they offered them a partnership agreement during the middle of the project. And so the contract transformed from a typical construction to a partnership. A default has arisen. And now the tribunal has to deal with another set of problems, which is basically the characterization of the contract and the parties' relationship and the multi-hatting. So that's one aspect. And I've seen, we're talking about value engineering. I know this is a bit off topic, but I think it's interesting because I doubt anyone would have faced that situation. So here it goes. So they have been, we're talking about value engineering in relation to the project, but think about value engineering in a reverse way in relation to the contract terms and dispute resolution in a very bad way. So they have said, if the contractor is a claimant, they have to go to court. If the employer is the claimant, they go to arbitration.
Ooh.
Right? And the issue is, they went to arbitration because the employer wanted to apply LDs and wanted to collect money. But the contractor said, no, but they can apply because I have claims. They told, no, you can't bring counterclaims because the original clause says if you have claims. And then you have a debate about whether the term claims applies to counterclaims in the same set of proceedings. And you have the whole arguments about unity, parallel proceedings, everything. And the tribunal has to deal with that. This is the way sometimes people draft their contracts. You sometimes wonder whether they were asleep, whether they were conscious. But I'll tell you one thing. The issue is, with these types of contracts, with these types of demands, sometimes unrealistic, at the end of the day, there are contractors who are willing to take these projects on board. And because there are people who are willing to do it, they will tell you, well, if you don't like it, there are others who can do it. And that's, I think, where the problem is. Now, ultimately, the system cannot sustain itself in that manner, but this is where we are at the moment. So my short answer, I don't think that it can be static. I think it will evolve, and I think it will change drastically.
Yes, I mean, it is systemic, as you say. Robert, what do you say?
I wrote this down. Let me get it right. It's my closing statement then. Oops.
Be quick. Not a statement, just quick.
It's not a statement. It's just a few words, just in the right order. Be realistic. Be ethical. Share, understand, and deliver the needs and interests of the parties. Challenge the norm and work collaboratively. That's it. See?
Beautifully put. Amma, what do you say?
I think there will be evolution, and we already have seen this vertical integration, there are different ways of doing the construction differently, and it's inevitable that this will happen.
Thank you. Anand.
I think, Karen, the situation is bound to evolve. There will be evolution, like it or not, because I believe that technology and off-site contracting will play a big role in the future. You will have building which will be manufactured off-site, or even 3D printing, for example, of buildings, which is being done, for example, now in Dubai. Large buildings, or I think 7 stories, is it not, Professor? In Dubai already constructed. So everything is controlled, no labor, machine, robots, drones, and so on. That's the future of construction. And of course, no dispute.
We've also seen the Chinese moving a building downtown on using robots. They were moving a whole building.
Yeah.
Oh my goodness. So kicking and screaming, but evolution is the answer. Well, I think we have to call this discussion to a close. Thank you all very much indeed through your efforts. And Professor, once again, thank you for that absolutely brilliant lecture. Much obliged. And I'm handing back to Dean, I think.
Thank you very much, Corinne. Thank you very, very much. I thoroughly enjoyed the discussion. It took us all the way around the world, from Dubai all the way over to the Caribbean, which is what, 11 hours, and then all the way around. And I'm sure we all benefited immensely. At this time, I'm going to be inviting Mrs. Broadber, Lucille Broadber, if she'd give the vote of thanks. I know we're close to the end. Can Lucille, would you please?
Hi, good evening. Hi, good day, everyone.
Yes,
it is great to see so many of us connecting virtually, although we are operating in different time zones. In these times where changes are taking place so rapidly, the importance of our relationship with each other and how best to use our linkages as we meet our new norms cannot be overstated. And I think that there was one time when I noticed that we had about 99 persons logged in. Now, the more academic part of this program is now ended. It's now coffee time. And my inspiration today came from a young female Jamaican artist by the name of Coffee, spelled with a K. And her international chartbuster, Toast. I don't know how many of you who are online who know this particular person, but you can perhaps check her out on YouTube. You might be wondering what really is the connection with coffee and this webinar today. Well, we're here toasting Maurice Toppy. And we're not talking about the charred bread we eat sometimes for breakfast, but the gesture of respect we give when we're honoring somebody. That's the thing we do in Jamaica. We toast people. So Maurice, I'm here using some of the words from Coffee Song Toast to celebrate and thank you. Toast, we are not only blessing you with a force. We give thanks like we're really supposed to. We give thanks for your journey. Earning is just a plus, and gratitude is a must. Maurice, researcher, writer, mentor, who decided that he would make Jamaica his home, not only to earn a living, but to impart his vast knowledge to all of us. The word thanks, blessing, and gratitude are strong words that we sometimes forget to say or to show. Christopher Malcolm, your leadership at the Jamaican International Arbitration Center cannot be overstated. Working with your team, you have maintained an international space that deserves recognition. The level of the discourse and its reach speaks for itself. While countries across the road closed their doors, you kept yours open. You found ways to continue positioning Jamaica as an international center for arbitration. Your focus was steadfast and singular in its purpose, even the heights of a global pandemic, and speaks to one of the many COVID-19 lessons which we all hear about and sometimes have heard people talking about. And it is said, when the dust settles, we will realize how little we need, how very much we actually have, and the true value of human connection. It is safe to say across so many continents and so many time zones, we connected here today. The team that worked on planning this function, Nadia Henry, Marlon Griffiths, Akeem Wilson, Tamika Campbell, Denise Erkins-Jones, thanks so much for putting this all together. Without your support and all the works you have put into organizing this program, this event would not have been possible. And I'm going to mention here, this is one of the better, call it conferences, seminars that I have ever been to. I think it was a wide range of speakers, the knowledge that they had, the depth of knowledge. They were not just centered in one thing, okay, I'm a quant-surveyor, they're a quant-surveyor manager, or whatever it is. It was really very good and thought-provoking. Dean Burrows, chairperson, my colleague, quant-surveyor. You are the starter today. Your role is one where you're expected to be tactful and impartial and to keep us on time. You did an excellent job. Dean is not only my colleague, but we're so different, but I think we still have the same value. Your usual calm and professional manner was on show today. Our moderator, Karen, your bias speaks to you just being the person you want if the battle is going to be hot. And you've been the type of advocate that most clients dream of instructing. It is now showing in your role as moderator. And the questions you asked, I congratulate the organizer for making such an excellent selection. Your ability to weave a virtual tapestry out of all the diverse presentation resulted in an experience we all found fulfilling. A job well done. Oh God, our guest speaker, I don't know what I was expecting to hear from you tonight, but I could not have gotten any more. It is said a good guest speaker is one that is knowledgeable and meshes well with the audience. We were not disappointed. And I'm going to pick out a couple of the areas, you know. First of all, this constructing the construction landscape. I could not think of a better title for your presentation. Crisis management as a major tool. I think that this is something that we use pieces of this in Jamaica, and I can only speak from the Jamaica experience, but we never ever put it on the forefront. And it is something that I know that I'm going to start implementing when I'm managing projects, because it is, and introduce it also to the contractors that I work with. The construction industry, I'm going to agree at this time. I think that we could be in a crisis. I believe, that a lot of the problems that we're having should be dealt with at the beginning of a project. I feel very strong about it. Put it on the table, about it, and let us see what the strengths and the weaknesses are in this particular project. Our international thought leaders. Everybody there had a special skill set, but they were so wide in terms of their knowledge base. I believe that the conversation coming out of what they had to say was very good. And I don't know if there's any way that we can, I know it's going to be on YouTube, but this is something that I think that we perhaps should use at another time, because I know I really gained a lot from it. For our sponsors, I know that Dean had already mentioned them, and that was Jamaica Standard Products, Caribbean Development Bank, ADB Consultant, and I would like to state that Mr. Lee, I just want to say special thanks. It's nice when consultants can contribute back to something that they really believe in. CP Malcolm Management Dispute Practitioner, Island Blue, Jamaican Blue Coffee, and Jamaica Deposit Insurance. COK Solidarity Cooperative Credit Union, and our media partner, Hive TV. Thanks so much for your contribution and your support. And if I have forgotten anyone, my apologies. So in closing, I would like to thank you all for your participation. Your presentations were excellent and dealt with the stated issues effectively, resulting in the discussion being fulsome and thought-provoking. Jamaica way, walk good. Bye.
Thank you all. Bye.
Bye-bye. Thank you.
Bye. Bye.
Thank you. Bye-bye.
Thank you all very much. Good night.
Thank you all. Good night. Bye.
Bye. Bye.
Good
Night.
Bye-bye.
Bye-bye.